Of every letter the IRS will ever send you, this is one that you cannot afford to misread. Letter 1058, also sometimes labeled as LT11, is the final notice of intent to levy. If you own a business and you owe 6 figures to the IRS, this letter just started a very important 30-day clock. And what you do inside that window can be the difference between keeping your bank accounts and your receivables or watching the IRS possibly take both. So let me show you how this letter really works and why the 30 days is really an opportunity and not just a threat. So here's what separates this letter from the other collection notices before it. So if you read the full title, it says Final Notice of Intent to Levy and Notice of Your Right to a Hearing. Those last words are the most important part. Federal law requires the IRS to send this notice and then wait 30 days before it can levy. And a levy simply means the IRS can reach into your bank account, garnish payments, or hit your accounts receivable. But let me make this levy real or describe more about what happens. A bank levy freezes the funds in your account on the day it hits. The bank then holds that money generally for 21 days and then sends it directly to the IRS. So for a business, this can mean checks bouncing, payroll failing, vendors unpaid, and this can continue for that period until your bank account gets wiped out or the IRS releases the levy. But one type of levy that can really get businesses is the accounts receivable levy. So the IRS sends notices to your customers telling them to pay the IRS instead of you. So think about that. Your incoming cash flow stops at the source, and every client you have now learns that you're in trouble with the IRS. So that's not just a financial hit, it's reputational, and it can possibly something that ends the business. So this letter, 1058 or LT11, is the warning shot before the IRS brings out the heavy artillery. And there's also a quieter consequence. So the failure to pay penalty is generally 0.5% per month. But once this intent to levy notice sits unpaid for 10 days, that penalty doubles to 1% per month. So not only does the letter 1058 threaten your assets, it also accelerates that penalty meter on what you owe, and the amount you owe will continue to grow faster. But here's the most important part, and why I said in the beginning this letter matters so much. That 30-day window the IRS gives you isn't just a countdown to disaster like Mission Impossible. It's your single best opportunity in this whole collection process. Within 30 days of the date on the letter, you can file Form 12153 and request a collection due process hearing, also sometimes called a CDP hearing. When you file on time, 2 powerful things happen. First, levy action stops while your case is pending. The IRS can't seize while you're in process in most situations. And second, you get a formal seat across from the IRS Independent Office of Appeals to negotiate a real resolution. And the things you can resolve in that meeting with IRS Appeals are resolutions like an installment agreement, also called a payment plan, a partial pay installment agreement where you pay what you can and the rest may be forgiven, an offer in compromise where you might be able to settle your tax debt for less than the full balance if you qualify, currently not collectible status, essentially hardship status. It's a pause on collections if paying would essentially cripple the business or yourself individually. And in other circumstances, you may be able to challenge the underlying liability itself if you never had a real chance to dispute the amount. And you can also bring up penalty abatement. So that's a lot of things that you can discuss with the IRS appeals officer who has real discretion to make decisions in your case. But if you miss that 30-day period, that CDP right is gone. Now you may still be able to get what's called an equivalent hearing, but you lose the automatic hold on enforcement, and you also lose the opportunity to protest any outcome in tax court. So if you have a six-figure balance or more, those are some big differences, and that's why you need to file that form 12153 as soon as possible. So really the main mistakes I see with the 1058 are just treating it like some other notice and letting the 30-day period lapse, calling the IRS without a strategy, or agreeing to a monthly payment that the business or yourself can't sustain, which just leads to a default, and then you land right back in the same, if not worse, position. So in close, if you take one thing from this video, remember the letter 1058 is the letter you build your defense around, not the one you panic over, as long as you make your move within 30 days. In fact, many times I'm actually glad when my client receives one of these letters, because then we can get a collection due process hearing and get in front of an appeals officer with real discretion to resolve your case fairly. So if you owe six figures, you have a business on the line, and the clock is running, you definitely need to seek professional help and file that Form 12153 for the CDP hearing before the clock runs out. But thanks so much for watching this video. Make sure to like and subscribe so you get updates when my next video hits. And please share this with another business owner you know who needs to hear it. And I'll see you in the next video.